order. Pledge of flag is led by Supervisor Conover.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
So we'll ask the clerk to do the roll call.
Mr. Conover?
Here.
Mr. Monroe?
Here.
Mr. Gerard? Mr. McDevitt?
Here.
Mr. Taylor?
Here.
Mr. Brock?
Here.
Mr. Kenny?
Here.
Mrs. Frazier?
Here.
Mr. Simpson?
Here.
Mr. Vanslow?
Here.
Mr. Dickinson?
Here.
Mr. Merlino?
Here.
Mr. Strauss?
Here.
Ms. Seaver?
Here.
Mr. Sokol? Mr. Beatty?
Here.
Mr. Westcott?
Here.
Mr. Thomas?
Here.
Ms. Wood?
Here.
Chairman Garrity.
Here. I'll ask the clerk to read the intent of the meeting.
For consideration of municipal home rule requests relative to New York State Assembly Bill A5297A, an act to amend the Public Authorities Law and the Transportation Law in relation to establishing the Corinth and Warren Railroad Authority and establishing the powers and duties of the town of Corinth, the county of Warren, and other municipalities located along the railroad line, and the municipal home rule request for the corresponding Senate bill.
Okay, this authority has been in front of the Senate and Assembly numerous times. I'll ask for a motion to bring the resolution to the floor. Motion by Supervisor Conover, second by Supervisor Monroe. All those in favor?
Aye.
Okay, now we'll have discussion on the resolution. Supervisor
I
Westcott.
oppose the resolution to
Okay.
bring it to the floor
Okay,
at this time.
who would like to? Supervisor Kenny.
Yeah, is there a cost associated with this, or savings, or is it neutral?
It's just a vote no.
The objective is, right now, the railroad itself is paying for itself through the fees that the operator submits to us. The arrangement that we currently have is that the idea is those fees are to cover the cost for both the town of Corinth and Warren County. There is, however, under the arrangement, the possibility that there could be, even now, some sort of a significant loss of some kind, and if it was not covered by insurance and there were not sufficient funds in the reserves that we have on the railroad, there could potentially be a cost to the municipalities if they're so inclined. When I say they're so inclined, the contract with the operator allows us out and them out should we have such a failure on that kind of significant loss. The problem, of course, is if there was that kind of loss, then we would also no longer have a railroad or an operable railroad, so the board would have to make some decisions in that regard. It is envisioned, at least from what I can see, and Martin could comment on this also as well, and I think he should as county attorney, but the idea was to simply transfer everything over to the authority, have the same relationships. The county would still provide assistance in terms of people, and just like it does now, and there would also be the revenues and things to support it. Now, will the authority, in the end, when you get all said and done, will there be sufficient income? If it stays similar to what it is right now, everything should be status quo, but if things grow, things could change. So I can't say, unfortunately, there's not like a black and white answer to your question, but the idea or the theory was just to create an authority, essentially have everything operate the way it has been. There is that potential for losses and therefore the potential for money. The authority will have some additional expenses because it would have to comply with the PAAA, as many of you are familiar with in terms of these authorities and local corporations. So additional accounting costs and things, so there will be some expenses. And the operations dictate the amount of fees that are available. The more successful the operations, the more successful the operator, the more the fees are available to cover these types of costs. But we would have that same issue, I believe, whether we owned it or it was in the authority. Martin, do you have it?
Well, thanks, Paul. As I look at this, I think this is a mechanism, as I've stated before, I stated at the DPW committee meeting, that this is a mechanism to provide insulation and protection to the county and its taxpayers. One of the questions that I've been asked a number of times, and along the lines of what Paul has said, is the property of the county, the property of the town, it's intended that those properties, those assets will be placed into use not necessarily ownership, but use, et cetera, by, the authority. The authority is scheduled to exist for a term of 30 years, or until such time as, if it has bonds and obligations to pay after that, longer than 30 years, or until such times as it cannot secure a railroad service. At that time, the assets come back to the county, the town respectively, pursuant to whatever agreements we have reached. But the idea would be that they have control of those assets, the authority would have control of those assets. We would have reversionary clauses in contracts that we would negotiate now with the authority, so that at the end of that 30-year term, the end of operations, the assets that are now in the name of the county or the town respectively would come back to the town and the county. So as far as costs, I can certainly see there could be some costs, as Paul has indicated. But I think as far as additional costs coming out, expected additional costs, I think the idea is to just kind of continue the way that this is, just have a different entity in charge of the assets.
Supervisor Drury?
I just, I wanted a comparative to, where we sit now in operations. I think Martin addressed a little bit with the insulating value that it gives. But, I would just like to explain the inception of it, how we get from here to having an authority, how that makes it better, and get it, if you could boil down so I could understand that a little bit better.
So what you're being asked to do today is what you've been asked to do on a number of other occasions, is to adopt a resolution for municipal home rule, which would be an indication to our legislators in Albany that we want to go forward with this. And there's actually resolutions here, home rule requests, that we have. Once the legislation is enacted, at that point in time, I think there is a transitional period where we are moving forward with transitioning assets to the authority. That's going to take some time. The authority is going to have to get structured. The authority is going to have to, the membership of the authority is going to have to be appointed. That's provided for here. The membership of the authority is going to have an ethics code. They're going to have bylaws, a whole host of things that they're going to have to do. That's going to take some time. But one of the most important things that we're going to do, it seems to me, is how we transfer these assets to the authority so that they have control of them. They can use them, but at the same time, we know that in the event after that 30-year period, or when they stop when they stop operations, those assets return to us upon terms that are acceptable to us. Now, 30 years is a long time, but I think we want to make sure that the county remains having an interest in these, future interest in these assets, so that they do return to us, or at least we have the ability to have them return to us. Maybe we don't want them, but at least we have the right to say we want them back. I hope I've answered your question.
Supervisor Dixon, you had your hand up.
I did. And I did remember what I wanted to say.
Okay.
So, for me to get this perfectly clear, what we're doing today is we're just supporting the motion or the assembly bill, so that we can move on to the next step, and the next step will involve how we actually transfer the property.
That's right. You're going to have, once you're being asked to do something today that you've been asked to do before and you've done before. Now, admittedly, there are some changes to the legislation, which I've outlined to you in the memo that Amanda sent on Friday. So there are some changes, and we can talk about those and go through those. But that bill with those revisions, that's exactly right, Supervisor. That's what you're being asked to act on today, to give the green light, if you will, to the Senate and the Assembly that we want to move forward with this before the close of this legislative session. Assuming they do move forward with it, assuming it is signed into law, it becomes a law for this body to then say, okay, how are we going to appoint the authority? Who are the members going to be? And how can we help them establish bylaws? What assets do we need to transfer to them? How do we work this in with the current agreements that we have with Iowa, et cetera? All of that's gotta be discussed and debated.
So we're hoping or thinking that this is gonna happen in the next week.
The message that has come through to me from Deb Capizzuti, who is with Assemblyman Steck's office, is that the legislature is anticipated to end their session this week, which is why we were told that if you hope or have any hope of getting this bill through, it would be this week for the legislation approval. Now, I must stress, too, that even if the municipalities adopt the home rule request, as you have before you, there is not a guarantee that the legislature will act on this still, but it was a matter of if you didn't take action to approve it, then there is no way they would act on it. If you do approve it, there is a chance that they could approve it this week. The problem has been, quite frankly, as some of you who have been here for a few years, as Martin has mentioned, this has actually been up before the legislature for quite a few years. Authorities are not popular, not favored down there, and so this has been a heavy lift to try to get the required approval to make this happen. This year, it just so happens that based on circumstances, it looks like there is a slightly better chance than we've had in the past, although here again, they're still disfavored. We could do all of this and it very well may not get approved just because of either a dislike for authorities, or it could be because they're still not satisfied, quite frankly, with the language of the bill, because this has all been developed very, very quickly in the past week or two. And whether or not this is going to be satisfactory to the folks in the Assembly that have to move this on does remain to be seen.
Supervisor McDevitt?
Yeah, I was wondering if maybe, Martin, if you could give us, maybe you can't, maybe a real-world example of an event that could occur as we sit right now and are structured right now, as opposed to having this authority in place, to try to highlight and verbalize the advantage of doing this. The word liability has been thrown around. So it is just maybe give me a better understanding of.
Well, right now, if there was some catastrophic event on the line, the primary responsibility for that, liability, if you will, would be with Saratoga North Creek, Iowa. They have insurance that they have to have pursuant to the operating agreement. They have assets, but so do we. We are the owners of the assets. This would be, and so as an owner, we are at risk of being approached in litigation, party to litigation, and exposed should there be an adverse outcome. This provides a further level. There's never an absolute level, Supervisor, but this provides, in my opinion, a very strong defense, a shield, very good level of protection for the county, because we would essentially no longer, as I understand it, we would no longer be in contractual privity with Iowa. We would be looking at this from afar. We would appoint members to the authority, that is true, but we would not be involved in the details of Iowa's operation, what they do, how they do, et cetera. That would be between the authority and would be between the authority and Iowa.
Just one last observation. The issue of the transportation of fuel oil, of oil, I think starting in Wyoming, Montana, and ending up in the state of New York, ultimately, the potential for serious tragedy, does occur and has occurred in different parts of the country. It is my understanding that those train cars currently do not pass through Warren County, but I am of the belief that they do pass through Washington County as well as some of the northern counties. So the world of litigation and somehow getting drawn into this in the event of and that would be a terrible tragedy if one of with the transportation of the oil. So I can I can appreciate maybe the intent and the protection being offered to Warren County, potentially.
Supervisor Brock?
Yeah, the authority protects the county or insulates it from, to a certain degree, against liability, but one of the things that concerns me about this is the possibility that there is a large catastrophe and there isn't sufficient money to protect the people who are damaged by it. You know, I'm not, it's more of a balancing thing. I mean, I don't want to see the whole county, you know, hit with a huge bill, but at the same time, what guarantees do we have that the people who might theoretically be hurt have sufficient money for their protection? Will there be a large enough insurance? Will there be, I don't know if the assets are large enough that they would have to have, excuse me, have to have insurance that would cover it. But it is a concern for me. I'm sort of playing the devil's advocate here. Is there a guarantee that if something, you know, it's kind of hard for me to say exactly what it would be, but where there's a large, but where it's justified so that there's enough money to protect the people who might be injured or the towns or whatever?
Chairman? There's no guarantee now, so I don't imagine there would be a guarantee should we change the situation.
Well,
where I come from is that I think this is a good idea because if the county is somehow brought into a liability situation because it's a passive owner, which essentially we are now, and we can try to reduce that risk, eliminate that risk through this type of legislation. I think that's, in my view, from the attorney's perspective, I think that makes a lot of sense for a municipal client.
Well, I understand that, and I also understand we have an adversarial system where one side has to take care of themselves and we have to take care of ourselves. But you know, what if it's some of our citizens who are hurt? We need to think about them, and there's no way of you know, sort of balancing it ahead of time, but I would like some kind of mechanism that makes sure there's enough insurance or something when we set up this authority to cover what we consider to be reasonable if there's a catastrophe.
Well, I don't know that I would read the legislation as proposed to say that you can dictate to them how much insurance they need. You would be appointing members. The town would be appointing members. You would be appointing members, and I think you can send a strong message to the appointees as to what your expectations are. But again, I think this goes to the point that I'm trying to make is that, you know, you want to set up an independent authority. You don't want to micromanage that authority for exactly everything that they're going to be doing or not going to be doing. Having said that, I would imagine, Supervisor, like anything else, if there is some type of catastrophic loss where there are not sufficient assets, not sufficient remedies available, and the county feels that it needs to be able to step in and do something, I think we examine that situation at that time, the facts and circumstances that brought about the loss, and who has been harmed, what's the nature of the harm, and we look at it at that time and we see, is there anything that the county can do to assist? Is there a need for county assistance? And then if the answer to that is yes, what can we do? How within our means can we provide that assistance? So I hope I've answered your question.
Just one more. Could we have our own insurance to cover that, or would it just come out of the general fund or whatever?
Well, we have general liability insurance. That's a question for our insurance agent. But again, I don't envision us I could be wrong about this. I don't envision us continuing to hold this as an insurable interest if it's owned by an authority and we don't own it.
Supervisor Stroud?
Yes, thank you, Chairman.
Now, this authority would be responsible for maintaining the railroad and having its own insurance and so forth?
Yes.
And where would it get the funding to do that?
Funding through well, Paul may want to address this, but go ahead.
Yeah, it's, as I mentioned earlier, and I'm actually glad you brought it up because I was thinking about trying to maybe just clarify and add to my earlier remarks on funding. The setup right now is as I mentioned earlier, is the operator pays us a fee, us in the town of Corinth, a fee. We in turn use those fees to offset our cost associated with the railroad. So far, and we've been successful in that so far. And then we've also set up a reserve fund for a significant incident that may happen on the railroad, such as a washout of the tracks or something like that. So we currently have a system in place. However, it's totally dependent on the fees, and I can see situations where those fees may not be enough. So the town of Corinth and Warren County could have to come up with additional funds if they wanted to continue to see this railroad operate. When we put it into the authority, I see that the authority would, the idea anyway, at least what I had originally envisioned way back when we first started talking about the authority would essentially step into the shoes of the town and the county, and they would get the revenues, they would pay out the cost. Now, is it possible that that authority may not have enough money because they have to pay for attorneys, they might want to add insurance for the rail line, as Martin just mentioned. As I mentioned earlier, they have to pay for the PAAA responsibilities, which is going to be additional cost. If they need additional funding, I could see them coming to the town and the county and saying, hey guys, we can't make it on the money that we have right now. We would need some additional funding for the operation of this authority. Will that happen? Won't it happen? I can only conjecture at this point because it really all relates back to the fees that are earned from the operator. We're going to be negotiating a new operations contract going forward for the next 5 years in about a year. So a lot of it will depend on what those negotiations are. Currently, for instance, the operator is paying taxes on property in Hadley. That we own in the town of in Saratoga County because it's not tax exempt, and the authority would have to pick up that responsibility as well. But there have been sufficient revenues to cover those costs to date. So, you know, is the hope that there's enough revenues to cover the costs that they have to face? Yes. Can I, in any fashion, guarantee that'll be the case? And have we actually calculated out what those new additional costs will be, such as for attorneys and stuff? No, we have not. So it is within the realm, quite honestly, a possibility that the authority could not have sufficient money. But on the other hand, I would think that there is quite a bit of funds there now that it should cover it. And as I mentioned, we'll also be negotiating with the railroad, you know, going forward for the next 5-year contract coming up. So all of these things could be put together. But the idea behind the authority, as Martin has mentioned, though, has long been, and when I was county attorney, it was always my recommendation to you to have this for liability protection purposes. To me, the value on that is what the greatest purpose of this railroad authority is, while also seeking to maintain some level of control from the standpoint of at least being able to appoint the board members.
I can see some, if I may continue, I can see some value in some protection in terms of liability for the authority, but the bottom line is if we, and I'm not so sure who we is, I'm assuming it's Warren County, is responsible for financing the track and making sure that the track's up to par, and all that's very expensive. And if we don't fund the authority, and the authority can't fix the track in accord with, you know, recommended standards, and there is a fatality, or there is a casualty, where fatalities may happen. Since we didn't fund it, the liability door is still wide open, and they're going to sue the county anyhow. If we're the ultimate, you know, holding the purse here. So.
Well, but I don't know that that's the case. As I understand what the county administrator said, there may come a time when we are being asked for additional funds. The maintenance of the rail lines is all on the operator. We're not going to be we're not gonna, we do very little maintenance now. We're not gonna do any maintenance under this new arrangement. That will be between the authority and the operator.
Well, okay, well, maybe I have to reread 2681E, paragraph 2, which, you know, is on page, at the bottom of page 6 of 13, and goes over to page 7 of 13, and it, you know, the language seems to think that the authority is ultimately responsible for maintenance of this railroad.
Right. I agree with that. Ultimately, right now, we're responsible, but what we've done is we've passed that responsibility off to an operator. I would imagine the authority will do the same thing. Again, as Paul said, they're stepping into the shoes of the town and the county.
But again, it takes the governance of it away from us, who have to pay for it, and gives it to an authority.
But, yeah, right, it gives it to an authority, that's right.
Yeah, so we don't have any say other than appointing 3 members of a 6-member authority in how it's governed.
That's right. That's the idea behind an authority.
Is this, one more, is this tract that we're talking about, the ownership of this tract, it begins in Corinth and goes up to North Creek, is it? This actual rail line, or?
That's correct. Warren County, the portion that Warren County owns runs from Anton Road in the town of Corinth and goes north to North Creek. Just north of North Creek, Iowa Pacific owns the railroad tracks up to the north of that. To the south of Anton Road, just before, to a point just before you get to Saratoga, the town of Corinth owns those tracks. And then from that point I was talking about, where just before you get to Saratoga, those are owned by, it's either D&H or Canadian Pacific. Canadian Pacific bought out D&H. But that part of the line's under their control, but the town of Corinth has trackage rights, meaning they can use those tracks. So that's how the train that we currently have gets from Saratoga to North Creek.
Yeah, well, that answers my thought, my curiosity, because I knew the train went from Saratoga Springs up to North Creek, and why wasn't it Saratoga County and Warren County Authority versus Corinth and Warren County?
The reason is because the town of Corinth was the agency that chose to buy the tracks. Saratoga County did not buy the tracks. It was the town of Corinth.
So the town of Corinth also has to pass this?
Yes.
That's correct, and I did call Dick Lucia this morning, and his board did unanimously pass this legislation.
Okay, thank you.
Supervisor Wood.
I just had a question. During committee, Martin, we had a lot of discussion regarding bonding and potential issues. Should the authority bond and then something happened to it, and potential liability of the county if things were to revert to us. Do you have any more information on that, or could you go into it? I noticed when you sent out the changes that we had talked about having some limitation on the ability to bond for. I didn't see any changes with that, so I'm assuming nothing has changed. It's still the original legislation, which really doesn't cap the ability of the authority to bond.
Well, it has been addressed in part in that the legislation still says that it has the ability to, has the power to borrow money. But what they did do is they added, through our discussion, they added a new section 2681F, county approval required, which indicates that a project having an aggregate cost exceeding $1 million, including but not limited to the acquisition of real property by the authority or the expansion of the authority's railroad facilities, may be undertaken by the authority unless such project is approved by ordinance of Warren County, adopted by a majority vote, and approved by the Board of Supervisors. So, if they have this is how you see this language presented in the Public Authorities Law. $1 million is actually kind of on the low side. I've seen $10 million. I think I saw the Syracuse Airport Authority that had like $100 million or maybe more, something like that. But that's a different arrangement. So here, if the authority had a project that they needed to borrow for, part of their borrowing process in order to get bond resolutions, in order to work with a financier, in order to work with a bank, they would have to, for any project over $1 million, part of that they would have to obtain an ordinance, or if you will, a local law from the Board of Supervisors that gives that prior approval to do so. So that's the tie-in with the bonding or the borrowing. and I actually like the way that this was presented, and I think it gives this board a say and a permissible say in how much money the authority can borrow.
Okay, and as far as, say the authority goes away, becomes defunct, expires, whatnot, it's my understanding that we would be turning over our tract to the authority. If there are outstanding bonds, what happens then? The authority is no more...
Well, the legislation provides that the authority continues until the debt is paid off. If the authority is not engaging in operations and there are still outstanding bonds and obligations at that point in time, those bonds and obligations are going to have to be paid.
Sure.
The assumption is the railroad will continue at operation at some level, or there will be some other means of arranging for the payback of that debt.
Okay, thank you, Mark.
Another reason to keep control of the authority's debt limits, so that in the event that this doesn't work out, the authority has not incurred large sums of debt that can't be paid off.
Supervisor Beatty?
Thank you, Mr. Chairman. I'm probably gonna vote no on this today, for a number of reasons. I still don't have a good handle on it. I think we're kind of rushing this whole process. I don't think we're giving it full vetting, even though I appreciate the meeting right now. I looked at, we're going to establish the Corinth and Warren Railroad Authority, and yet I looked at the letter from the authority's budget office, State of New York, and Corinth Industrial Agency has been out of compliance with state law in putting forth their budget 3 years in a row. So I'm very leery now of going into, quote, business with Corinth when they have a tough time following the state laws. In fact, they're being censored. Now, that was back in 2013. I don't know. I don't have an update. Maybe they're out of censorship, but the state took it to send them an official letter of censorship. So that alone concerns me dramatically. And so we get in partnership. We create this authority with Corinth. That's enough for me. But the other fact that I don't see enough positives to offset, I think, still are liabilities, like Supervisor Stroud brought up. I believe a couple of other supervisors did. I don't see enough. I still think we have liability. I still think the county, although we do put in, quote, another layer of protection, I don't think we're ultimately out of that whole process. We still could be held accountable, and so I'm just not comfortable with this at all at this time, so I'll be voting no.
Supervisor Dixon?
Although we're having a great deal of titillating conversation here, I think we shouldn't lose fact of what we're doing here today. All we're doing is asking the legislature to act on this authority. A lot of the questions and discussion have been about what we would do if we had that opportunity. That's a discussion for later. First, we need the opportunity to see if we need to do that. So, although they're all good points, I think we have to look at the fact. We're just here to see if we want to ask them to give us this option to go to an authority. Not that we're going to do it or not do it. We just need that option, and I think we seriously need that option.
Supervisor Simpson?
Is there a clause that allows for dissolution in the less than the 30 years? Say everything, hits the skids, what happens then?
Well, a couple of things, Supervisor. I think that an authority is created by legislation. It can be dissolved or terminated by legislation. There's also the provisions in here that say that it automatically terminates at the 30-year period, or until such time as, if it's longer than 30 years, until such time as the indebtedness is paid off, or until such time as a railroad service can no longer be secured. And under any of those events, what happens to the assets of the authority, which were once, at least in part, assets of the county, those are expected to come back to the county and town respectively pursuant to agreements that we reach early on in this process. I mean, I think we want to address those agreements now. Not now, but if the legislation passes and you decide that you're really moving forward with this in earnest, I think then is the time when you want to address those agreements in as much detail as possible to anticipate as many things that could go right, could go wrong, and how would those assets come back to you and what mechanisms are in place to do that. I do just want to address something that Supervisor Dickinson said. I think that to me, it's a fair statement that if you pass this resolution today, I think you're sending a signal to the state legislature that you want to move forward with this authority. Now, there may be some bumps and bruises along the way with moving forward with the authority, but I think you're telling the state legislature that this is our plan. We intend to act on this. We intend to act on this new legislation in good faith and move forward with it. It may, to your point, Supervisor Dickinson, it may get to the point where we have this legislation and we find that for whatever reason we can't act on it. But I think there has to be, I think today if you pass this resolution, you're sending a signal that you're going to make a good faith effort to move forward with this authority.
Supervisor Seaver?
You know, I think there's one thing that Assemblyman Steck and I will agree on, and it probably won't be my vote today, but it will be the fact that he's frustrated with a lack of notice and information ahead of time. And I can tell you that as of Thursday, I know I reached out to both our chairman and our county administrator for some more information or just to find out more about this meeting. And then on Friday at 3:30, the supporting documentation came out. We're only at Monday morning at 11. I keep hearing you, Martin, talk about I'm asking you to do something that I've asked you to do before, but I can't recall a time that I've had a vote on something like this where it's gone into the state legislature and then what I'm hearing is you really can't go back. I mean, once it's passed on to them, I'm hearing a couple different answers about that, but I have a laundry list of questions, and from Friday to this morning, and I did sit in on the meetings of Public Works. I have looked at the YouTube video again. I haven't read the minutes. I don't think those were available as of this morning. But in a weekend, there is not a shot that I can do enough homework and make a good decision. And I'm sure perhaps a lot of the other supervisors can if they've been in this position before, if they're more familiar with the authorities. But I'm not, and I'm not prepared to vote on it, and I can't support it for just that lack of information. Additionally, though, Martin, let me hit out my questions to you real quickly. And, you know, I'm reading from the Office of the State Comptroller's website, and here it says that public authorities play a significant role in the debt structure of New York State. Currently, over 94% of all state-funded debt outstanding was issued by public authorities without voter approval. Just to me, right off the bat, there's an awful lot of debt without voter approval, and it could just be the fact that I'm not clearly understanding the purpose of this authority or why it's such a rush. I've talked to other supervisors that have been on the board years previously. They said they've always been talking about this. Perhaps Supervisor Kenny can shed some light on that. I know you've had quite the tenure with the board, so I'm sure this has come up before. I don't know necessarily, though, why we need to make a decision within 48 hours. And I know that I cannot make the best decision possible for the people that I represent within that time frame. So I would vote no. But if you'd like to respond.
Mr. Chairman, couple of things, Supervisor Seaver. I think, and I haven't read exactly what you're reading from the State Controller's website, but there are state authorities and there are local authorities. State authorities come to mind: the Thruway Authority, Canal Authority, things of that nature. This is a local authority in contrast to a state authority. We've also made sure we've taken time in this instance to make sure that there is a fail-safe on the borrowing, and Supervisor Wood asked me about that. That may not be sufficient for some of your needs. I would understand and respect that, but we did the best we could to put a provision in there to make sure that you had a say in any funding for projects that goes over $1 million. As far as my statement that this has come up before, it has come up before. I've been here, Supervisor Seaver, I've been here since 2011. I could be wrong. I could be wrong, but I think this is the third time in my short tenure here that this has come up for a vote, and I believe the past two times it was favorably supported. I believe that to be the case. What's different here is we have this special meeting. I don't think we had special meetings for the last two times. And again, I could be dead wrong about the three times. I know there's at least one other time where this came up where I was here, and perhaps two other times. So we have a special meeting. We're a little crunched for time that we haven't been before. I believe, as the county administrator indicated, Ms. Capizzuti, Assemblyman Steck think that, the environment this year might be friendlier to getting this done. Doesn't mean we have to get it done. You can always say no. But that's why it's here, and that's why it's here before you today, because we're nearing the end of the legislative session. It is not a vastly different bill than what this board put forward in prior sessions. That's the point I was trying to make. I wasn't trying to, snow anybody here. I was just stating the reality. There are some changes. We went through those changes at the DPW meeting. I opined at that point, I believe I opined that I did not consider them to be major changes. Since that meeting, we've added the $1 million project approval provision. I think that's a wise thing to have added. So that's my position on that, and the facts are the facts before you.
Mr. Chairman, can I just add to, I think it's important to know that, and I understand the frustration when things come to you, and as you know, we work hard to try to get things in as far in advance as we can now for you. In this particular case, though, I want you to know, this is not something we had any control over. The way the legislature works is after the budget has been done and these things keep moving along, you finally get an opportunity to see something like this addressed. And in fact, I went down to Albany, I can't remember the exact day, but it wasn't that long ago, I want to say within the past 2 or 3 weeks, to meet with the representatives to see if there was any opportunity to get this going. And that's when, for the first time, some of the issues that they had that they wanted to see changed in this legislation came up. So then there's a lot of conversation that goes back and forth down there, and then finally, and unfortunately, like I say, it didn't happen until last week where they finally came out with, we had the first go run at it, fortunately for the committee meeting, but we did not get the finished bill here with the new language in it until Friday. So I know it's frustrating, and I know that that makes it very difficult, but I want to, assure you this is not because of your county staff, it's just it's the hand that we've been dealt with. And ultimately, of course, it's up to you folks to decide whether or not, to weigh all of this and weigh the importance of it, and then make your call on it.
Supervisor Westcott.
Thank you, Mr. Chairman. I just wanted to briefly respond to Mr. Dickinson's comments. I watched the June 1st YouTube video, and I think you addressed it again, Martin, on the realities of if this resolution passes and then the Assembly and the Senate, the governor signs this into law, that certainly the expectation would be that we move forward. When I watched the YouTube video, I thought it was a little stronger than that. Maybe I took it wrong that they could write the law that directs us to do it, whether we have second thoughts or not. Is that an accurate statement or interpretation of your prior comments on June 1st? Because it sounded like in that meeting, this happens, it sounds like it's pretty much a done deal, if the state passes it. I just wanted clarification on that.
I haven't thought about it in that sense as far as directing us to do something. I think I'll stand by what I've said. I believe I said at that meeting, and I'll say here, is that I said here, you take this action today, I think you're sending a strong message to the state that you want this done. As a result, if I'm in the state legislature and I get a message of home rule from Warren County and from the town of Corinth, I'm thinking they want this done. Why do they want it done? Because they're going to follow through on it.
So the point is it's not just a take it for consideration. It's us saying pretty strongly that we want to see this happen, and if they do it and then we back out after it's passed, that would be sending them the wrong signals at this point.
This would give you the authority to put the framework in place to get it done. I think you would have to make a good faith effort to get it done, to get the authority established, to get the assets transferred. I said to Supervisor Dickinson, it may be that circumstances arise where you can't get that done. I'm aware of state agencies that have certain state authority where they try to get things done and they can't get it done for whatever reason. That may happen here too, Supervisor.
Right.
It may not happen here. But I think you are sending a message that you're going to make a good faith effort to get this done.
That's an excellent clarification. Thank you very much.
Yeah. Yes, Supervisor Taylor or Supervisor Monroe?
Yeah, I came in to the meeting today pretty much thinking that I was gonna vote for this. And I'll tell you what I based that on. I've got some familiarity with two local authorities, the Glens Falls Housing Authority, Glens Falls Transportation Authority. I've never heard of a problem with either one of those. I think they're both very well run. And I don't see why this proposed authority wouldn't be well run. I am concerned though with Martin's comments about, if we pass this today, we should plan on going forward with it, that it would be probably unusual to back out, and perhaps even it might hurt us at the state level if we request something like this and back out. My other comment is that just in meeting the PAAA accounting requirements and legal fees that I can anticipate that organization having to make, I think we'd be increasing costs by, at a minimum, $30,000 a year, and maybe more. So I'm a little uncomfortable in voting for this, knowing that we'd be increasing costs over what we're paying now, and the unlikelihood of not going forward if we decide that we didn't want to.
Okay, Supervisor Monroe?
Question about the borrowing capability. As it stands now, under county ownership, we have the ability to borrow money based on our taxing authority, so we're both basically credit of the county. So you create the authority, the way the bond rating agencies or the prospective bond purchasers are gonna look at it, they're just gonna look at whatever revenue there is for the authority, right? Because there's no guarantees from the county on repayment of that debt.
I would agree with that.
So they're gonna have very limited borrowing authority. So I mean, it seems like in very simplistic terms, we're trading off control. We're relinquishing a degree of control in exchange for some limitation on our liability or some reduction of our liability. Is that a fair statement?
I believe that's a fair statement.
Supervisor Brock, Supervisor Seaver, and then we're gonna open it up to the public.
Does anyone know what the total assets of the authority will be if they take over the train? I mean, not the train, but the track. Is that, I mean, you would borrow against the assets, I would think, and then.
I would think that there would be, those assets would be valued as part of the transition process, and then you would also put into the mechanism the anticipated revenues to reach a borrowing limit.
But no one knows what the value of it is, or?
I don't know that off the top of my head. I don't. I've never seen an appraisal of the value of the rail line and its appurtenances.
Supervisor Seaver?
I'm sure I'm simplifying this, but, and as you all know, I've already stated I'm confused and looking for more info, but in this memo from Merton to Kevin dated June 12th about the municipal home rule request, you made a change, which to me looks very significant, from may to shall in, number 3, section 26818, the advances on behalf of the authority. And I'm just wondering, you've got emphasis added, the word may went to shall. Does this mean if they ask us for money, we have to give it to them? What is the, can you just explain to me what that subdivision 2?
Yeah. I can actually address that because I came up as one of the comments that were made when I was talking to the folks at the legislature, and I thought Martin did a really good job of addressing it, and that is they were concerned that they did not want to create an authority where we just, after it was created, then we decided whether or not we wanted to use it. So they wanted the word shall in there, that if it's created, that we will take in good faith the next steps. Now, I think what Martin's picking up on, though, is if you read it, when you read shall, you see all the different things that we have an option of doing, of either conveying, leasing, whatever all the language is in there. So it gets kind of interesting that if it says you shall do this, but it doesn't tell you exactly what you do, what if, as you were mentioning, Martin, what if the parties try in good faith to get someplace, but they can't for some reason? But I thought, Martin, you did unless you want to comment further on the shall, I thought you did a really good job in terms of explaining that if we ask for this legislation, we're saying to the legislature, and they in fact this was one of the changes that were made, as you pointed out, they expect that we will, in good faith, move ahead to try to set this thing up. And the idea would be to set it up in such a fashion that you get the liability protection that you want. And that's really a comment for Martin, but I suspect to get the liability protection that we want will involve some significant transfer of the assets.
And is it, just to follow up, is it customary then in any of these establishments, maybe even Buzz can answer it, that you see like drafts or, an idea of who would be on that board, or draft bylaws, or a draft mission statement, and all, do you get to see any of that before you sit here and say, yes, I want to make this an authority, or you say yes, and then all that, we won't have the ability to vote on those things or change, I'm assuming?
You would have the ability to appoint members. The way that I envision this is that the membership would be appointed. They would then take it upon themselves to draft bylaws. I don't think it's intended that we draft their bylaws. I do think it's intended that we have very serious, in-depth discussions with them about what assets they're getting, what our expectations are, and and under what circumstances those assets are coming back to us. I hope I've answered your question.
John?
Yes, how many miles does the railroad rent versus how many miles are owned by the county?
Is it 6 and 14?
I think we own about 40 miles of track, and I think Corinth is down around, I want to say 11, 12, maybe 15 miles, somewhere there.
All right, 18,
18.
And maybe 15, someplace in there, and 40.
But we certainly own significantly more track than the town of Corinth does.
All right, but the authority, which is responsible for maintaining the track, and may have cost burdens that I think are going to be shouldered mostly by the county for maintaining those tracks? Or is it going to be 50-50? I mean, since Corinth gets 3 votes, and we get 3 votes, which I don't think having an even number is a good idea to begin with, you might end up with ties in terms of, well, let's spend the money to fix up the track. I'm just thinking that most of that financial burden is going to fall to this county, but we only have half the vote in the governance situation of the authority. I mean, what if this county says, listen, this financial obligation, this financial burden, this financial liability, whatever you want to call it, is just too much. Let's make this into a rail trail. Well, we lost the governance to be able to do that. Now you have to convince the authority to do that, I guess. I'm trying to get a handle on this, and I guess I'm not alone in not fully understanding this whole thing, but I'm trying to. So my concern is Corinth gets half the authority, but doesn't have to have half of the financial liability, and we lose the governance over the situation. In other words, if we want to make a rail trail out of it, we can't, even with our 40 miles, because the authority makes those decisions then, instead of us. I'm concerned about that. Okay, thank you.
Supervisor Westcott?
Thank you, Mr. Chairman. I spent a number of hours this past weekend on this, and I put together a list that I submitted to the county administrator this morning of questions. I'm not asking for all those questions to be answered this morning. There's 26 of them. A few of them have already been answered. I'm just stating for the public record that I'd like my questions to be added to the public record and I'll be voting no for this at this time because I'm ill-equipped to make the vote. Thank you.
Supervisor Taylor? Just a thought. The primary reason that we want to establish this authority is to protect our liability. Why not just buy more liability insurance? I think we're at, what, 10 million now, Paul?
We don't have any liability insurance. It's through the operator. They're the ones that provide the liability insurance. I don't have the contract in front of me, so I can't tell you what that is.
We have liability insurance for the county.
Right, but doesn't cover railroad track operations. No.
All right. Same question, though. Why not increase the amount of liability that we carry on the railroad?
Well, I mean, you'd have to negotiate that with the operator, and presumably there'll be an additional cost.
Okay, I'd like,
Yeah, thank you, Mr. Chairman. I was, one of the supervisors that was around back when, we developed and went out, for an RFP. I think it was in 2010, 11, somewhere through there. And I can tell you that the railroad that we have today and the operation that we have today is nothing like what existed then. And in fact, what existed then was, not a great situation. Some of you that may have followed the issue, it seemed like every night the issue was getting banged in the media on one thing or another. Platform stations, the cost of platform stations, the lack of service, the lack of what it did. And so we harnessed our resources, our staff resources and our own resources, and we put together what I thought was a good RFP. We went out on the street and we were able to secure a preferred operator, and which I think has taken this asset to a new level, a better level, and that's a very good thing, I think, for what we were looking to accomplish. It seems to me that the question that we should be asking ourselves today, and if not today, perhaps on down the road, is, you know, what do we need to do, if anything, to take it to the next level? Do we need a group of people focused exclusively on this part of the transit business? Or can we continue to sustain it out of our Public Works Department, along with everything else we do out of our Public Works Department, from a staffing perspective, and running everything, you know, through this board? Or do we really need to have people really focused on this on a, shall I say, a full-time basis? And while I understand the importance of the liability argument, and while I understand the as a positive thing, and the other arguments that I made, this is the question that I have in my mind: is you know, do we need to think about this authority as a vehicle to help us really focus on this and take it to the next level? Because we should be asking ourselves the question, what if we find ourselves one day without an operator, right? What happens if we find ourselves missing an opportunity or not understanding something relating to the railroad, because we all deal with that kind of on a part-time basis, if you will, along with all of our other responsibilities. So I see this authority, while I'm not normally a big proponent of authority, believe me, and as I gather most of you are not as well, I do think that the idea of having a group of people focused specifically on this may be a wise thing, especially as we look on down the road. So yes, we do accomplish a number of things creating the authority, but I think that perhaps we might even be accomplishing something even more important. And again, whether it masses the votes necessary today for passage, or if it has to wait for another day, I'm not sure. But that would be the question that I think we all should really be asking ourselves. How do we want to organize for success going into the future? And I think we've come a ways in a lot of respects. Can we sustain it? And for how long can we sustain it under existing construct? I'm not sure. But I think this is an idea that has some merit and is worthy of our consideration. Thank you.
I'd really like to open up public comment. Jim?
I think Ron has a good idea, but we don't need an authority to do that. We could have, like Harrison is here, we could have 3, 4 people, volunteers, which we would have to have anyway to run the authority, and have them, you know, focus in on the railroad and look to the future.
Okay, I'd like to open this up for public comment. Please come up to the podium, state your name and, address for the, record. Please go ahead. Yeah, go ahead.
Travis Whitehead, Queensberry. Mr. Conover just told us how things are better with the new operator, and I believe that's true. But the operator, while he does not have to disclose his finances, he came in front of you just a few months ago and said that he had a 7-figure loss on his operations. So that is obviously not sustainable. It's not something you can say, we've got this, you know, you've got nothing. You've got a 7-figure loss, and nobody's going to continue to do that for very long. What you do have is the very real opinion that if you go forward today, there is no backing out. I mean, it basically becomes administrative steps, which must be taken and could fall apart somehow. But it is important today to realize that it is a critical vote if you go forward, and there's really no going back on it. We do know that there will certainly be additional costs. There's no doubt about that. Mr. Taylor just explained that. Getting through PAAA, you're going to be hiring lawyers and such. It's going to be more money. The potential for liability, nobody has come up with a figure to see what that insurance figure actually is that we have. Someone said 12 million, they believe. If 12 million isn't right, you know, go to 20 million. I mean, I know that it's not just the, you know, when you increase your liability, the rate doesn't, if you double what your liability insurance is, your rate isn't doubled. It only goes up a little bit. If you feel you need some additional insurance, then you should be able to negotiate that. The more you try to hold on, because there's some desire here to hold on to the reins of this authority. You additionally put in this 2681F, county approval required, over $1 million. You start tampering with things like that. Any lawyer that's going to come in here and say, because I've got a $100 million lawsuit here, and I'm thinking, you know, I might as well include the county in this because they've got some pockets. Of course they're going to include them in, and when he starts seeing, well, it looks like they have to approve all this stuff, you know, it's right there in the law, and I think, you know, it's going to fall apart, and you can't keep another lawyer from coming in and making that argument. Who knows what a judge is going to say. But I think that the idea that you're going to be much better off on the liability side, particularly if you try to hold on to a little bit of control over this authority, is illusory. So, you know, all in all, I think you just ought to think back at the kind of power that these authorities do have. Wasn't that long ago, Warren Washington IDA issued bonds for $85 million to buy the trash plant from Foster Wheeler, and they fell short in excess of $5 million most years on making those payments, and those monies ended up coming from Warren and Washington counties. So, you know, you give somebody a loaded gun, you better be careful because, you know, it could come back at you. Thank you.
Thank you. Anybody else wish to comment publicly? Please stand up, state your name for the record.
Skip Stranahan, 1343 Bay Road. I think what you're doing is you're giving 6 men in a room authority over Warren County's property, and you're giving them the right to sell bonds and mortgage the property in effect. Paul can speak on it if he'd like to, but what are they going to use for collateral to get their money with? The railroad line itself, or where would they get their money from that they're going to establish the authority with? So I think you're giving 6 men in a room more power than they deserve over our property, our personal property, and you may be transferring our property to somebody who's going to either put it in debt or lose it. So that's just my thoughts. Thank you.
Thank you.
Mr. Chairman, I just feel it's important for the record, though, to clarify. I certainly appreciate Mr. Whitehead's comment on the IDA and the trash plant, but I do think it's important just to clarify that that obligation to Warren County did not arise simply because the IDA went out and borrowed. It arose because Warren County, at that point, the board, agreed to be obligated to a contract which in turn caused the county to suffer those damages. So the IDA all by itself couldn't have borrowed money and it became our liability. And in point of fact, in that situation, it was a matter of the county actually agreeing. And I'm familiar with that transaction because that was before I became county attorney, and one of the things that we did, and Supervisor Monroe was very active and involved with it, is we went back through and worked like heck to restructure that deal with Washington County and Bob Morris from Morris Fitzgerald, and Fred took the lead on that. But so there is more to it than just simply the authority, locking you in on a bond. So I just wanted to clarify that.
Okay, Harrison, you want to?
I should say I'm John Salvador, but really I'm Harrison Freer, another gadfly in this group. I just wanted to bring forth the notion that as the rail loses money, there are other options that don't involve a rail authority that should be considered by this group, specifically some kind of rail trail that we've been advocating through the bike group and looking at multi-purpose trails that aren't of the vintage of rail, but are a trend in the 21st century that I think this board should consider.
Anybody else? Okay, we have one resolution in front of you. It's Resolution 283. Any more discussion on Resolution 283? We have a motion, seconded to bring it up for a vote, right? You want a roll call vote?
Yes.
Okay. Any more discussion on 283? Okay, we'll do a vote.
Mr. Conover?
Yes.
Mr. Monroe?
No.
Mr. Gerard?
No.
Mr. McDevitt?
No.
Mr. Taylor?
No.
Mr. Brock?
No.
Mr. Kenny?
No.
Mrs. Frazier?
Yes.
Mr. Simpson?
No.
Mr. Vansalo?
No.
Mr. Dickinson?
Yes.
Mr. Merlino?
Yes.
Mr. Stroud?
No.
Ms. Seaver?
No.
Mr. Sokol? Mr. Beatty?
No.
Mr. Westcott?
No.
Mr. Thomas?
Yes.
Ms. Wood?
No.
Chairman Garrity?
No. The resolution failed. Any other things to be brought in front of the meeting today? Anybody, any supervisors? Anybody from the audience want to bring anything in front of the board? If not, I'll ask for a resolution or a motion to adjourn. Motion by Supervisor Gerard, second. Supervisor McDevitt. Thank you.